Good morning and welcome to today's webcast, Outpatient Prospective Payments in 2019. Before we begin, I'm going to play a brief housekeeping video.
Welcome, and thanks for joining us. We're pleased to present another in our ongoing series of continuing professional education webcasts to help companies and individuals conquer challenges as they plan for what's next. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize how you both view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement or enter full screen mode using the controls at the top of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. You can download the group attendance sheet and a PDF copy of today's slides from the slide deck and handouts widget to the right of the slide view. You can ask our presenter questions during the webcast by typing a question in the Q&A window below the slide view and clicking Submit. We'll do our best to answer all questions during the presentation or follow up via email. If you experience technical difficulty during today's presentation, refresh your browser by hitting the F5 key. Today's session will offer you 1 CPE credit. To receive credit, you must meet the requirements as specified by the National Association of State Boards of Accountancy. You must attend at least 50 minutes of the session and respond to at least 75% of the polling questions, which we'll ask throughout today's presentation. To respond to a poll, click the button next to your answer. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon in the CPE Progress widget to open a PDF file that you can save to your computer. Don't worry if you can't download your PDF certificate today. We'll email a copy to you in 2 weeks. If you're attending this webcast in a group, you must complete our attendance sheet to receive CPE credit. The attendance sheet is available in the slide deck and handouts widget. Please have all group members sign it and send only 1 sheet per group. Also note that CPE credit can be awarded only to participants registered as themselves and isn't available to participants who view the on-demand version. As a reminder, the presentation you're about to see isn't legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
CLE credits are also being offered for this program. We'll be announcing the 5-digit code at some point during the presentation. Those seeking Kansas, New York, and New Jersey CLE credit are also required to complete an attorney affirmation form, which is available in the slide deck and handouts widget to the right of the slide view. I'm pleased to introduce today's presenters, Paul Holden, partner at Moss Adams, and Larry Vernaglia, partner at Foley and Lardner. And with that, Paul, I'll turn it over to you to get us started.
Thank you, Emily. Good morning, everyone. Great to see old friends and new on our attendee list today. We have a great program, a lot of changes happening on the outpatient side of reimbursement and regulation in 2019. Larry and I have had an opportunity to put together this presentation highlighting what we feel like are a few key points that your facilities and executives will need to be mindful of going forward in addition to legal counsel. When rules are being issued by CMS these days, I am encouraging most folks who read the Federal Registers or who are involved in rate setting and regulation, you really need to be looking at each of these rulemakings in their entirety and almost together, because each piece of the IPPS rule for inpatient services, the outpatient rule, Medicare physician fee schedule, renal, inpatient rehab, CMS is weaving together changes into each of these that are not only affecting those payment systems, but then are affecting cross-payment systems as well. And we'll talk about that more in depth today. What you really need to be mindful of is when these changes are taking effect and the language that CMS is using when they're implementing these changes. As a quick reminder, when we're talking about inpatient PPS regulation and rate setting changes, those go into effect in October of each year, while the OPPS or outpatient prospective payment changes along with the physician fee schedule are effective January 1st. not only do you have to be mindful of the date during the year when these changes are occurring, you also have to be mindful of which years these are in effect for, or which years were a cutoff point for certain rules and regulations that were going into effect. So this morning we're going to talk about the payment factors for 2019 and some key considerations there on how CMS is arriving at those payment factors. We're going to give an update on 340B. There was a recent legal development there that we need to discuss further. We're going to talk about Section 603. Larry's going to give us a refresher on certain Section 603 items to be mindful of, as well as certain considerations for co-location services. And then we're also going to talk about site neutrality in 2019 and beyond, and where CMS is heading in regards to site neutrality payments. So starting with the payment factors, similar to a DRG, the APC, or Ambulatory Payment Classification for OPPS, is paid on a base factor. On the outpatient side, it's referred to as a conversion factor as opposed to, say, a DRG weight of 1 or an operating DRG. For services after 1/1/2019, the base conversion factor for APC payments will be $79.49. You can see that's an increase of the final conversion factor from 2018 of $78.63 and change. If facilities fail to report their quality measures, they do receive a reduced APC conversion factor, in this case down from $79.49 to $77.96. This is similar to inpatient, and you can see as time has gone on how serious CMS is that facilities are not only meaningful users of electronic health record systems, but they're also getting their quality data back to CMS for not only payment rate and market basket updates, but for also value-based purchasing and other enhancements or penalties. In addition to the APC payments, CMS is proposing pass-through spending for drugs, biologicals, and devices of about $127 million or so. Certainly a large increase from 2018, but I would say the increase in 2019 is similar to what we saw in 17, 16, and prior. Regarding these payment factors, similar to the inpatient side, there is an outlier threshold for those high-cost cases. We've given the equation to arrive at the outpatient outlier here, but you can see from 2018 to 2019, there was a significant increase in the dollar cost threshold that facilities have to reach in order for that case to qualify as outlier. And we'll talk a little bit about outliers for a second, because this is an important consideration when we're talking about facilities who have recently gone through major system conversions or have done major overhauls to their charge description master or their pricing structure. Outliers come about when there's a case involved with a patient where, due to a hospital condition or a patient's condition in the hospital, when they become sicker during their hospital stay, not due to anything on the part of the facility, CMS reimburses for that higher cost case because the acuity of the patient changed during the stay, and CMS needs to reimburse for the additional resources consumed to bring that patient back to wellness. The challenge with outliers since the beginning of prospective payments for CMS has been that the outlier equation is driven by charges on the bill for the patient. But the problem is that pricing structures and charges are not always in line with patient acuity. So what can happen is that if the charges in a facility are exceeding the acuity of their patients, it can trigger outlier payments to the hospital that may not be representative of actual resources that were needed for patient care. So whether we're looking at outliers on inpatient or outliers on outpatient, it's always very important to look at your pricing structure in relation to your patient acuity, your case mix indices, things like that, because what you don't want to end up happening is that when your contractors end up coming around and doing outlier reconciliations, you don't want them to have the impression that you got outlier payments, but it wasn't for patients who needed that particular reimbursement. So a little bit of a tangent there, but an important one, because as we've seen folks overhaul their pricing structure, or now certainly with the transparency of charges, having to report those charges out to the public, this is an important area to be mindful of. When we're talking about the rate setting process each year for APCs, CMS is taking Medicare cost report data and they're taking MedPAR claims data in order to arrive at not only the base conversion factor amounts, but also looking at what the APC weightings are. There is a method that CMS uses to arrive at the APC weightings each year to determine what those resource consumption numbers should be. On the inpatient side, CMS uses an arithmetic mean process, so they are taking the true arithmetic mean, which is you add three numbers and divide by 3 to arrive at whatever that particular number is. Now, I'm just using 3 because it's an easy example. On the outpatient side, CMS actually uses the geometric mean for setting the APC weightings, which is slightly skewed compared to the arithmetic mean. But they moved to that method several years ago because it allowed them to better optimize the numbers from their standpoint. They still have not addressed why there's a difference between the calculation of weightings between inpatient and outpatient, but if you look at the geometric mean on the outpatient side, it is slightly more favorable to CMS than the arithmetic mean. What happens then is then when those weightings are arrived at, they are then multiplied by the conversion factor and other payment factors such as wage index to arrive at what the actual APC payment will be for that service. Now, one thing to note, and we mention these things because as Larry and I continue through the presentation, it's important to understand how CMS arrives at their conclusions each year, because CMS typically does not make decisions in a vacuum. There are times when they do, but more often than not, they are taking cost report and other data and using those numbers to make decisions prospectively about how hospitals should be paid. So we wanted to highlight in the beginning of this presentation how CMS uses your information to make those decisions. On the outpatient side, when we're talking about rate setting, it's important that providers are using prescribed CMS cost centers on their Medicare cost report, because unlike DRG rate setting for inpatient services, where CMS takes all of the cost centers on the cost report and collapses them into 19 categories, what CMS is doing on the outpatient side, specifically for your ancillary and outpatient departments, is they're multiplying straight across. That's why when we see things like changes for MRI and CT reporting, when they're looking at imaging modalities, or we're talking about subscripting line 90 for various provider-based departments, that's why it's so important that providers really understand how their data feeds into their ancillary and outpatient areas, that they're properly allocating revenue code 510 clinical services or 761 for treatment room when we're talking about infusion or wound care services. Because at the end of the day, CMS is taking this information for providers nationwide, and they're using this data to determine what is Medicare's true share of cost for those Part A beneficiaries, or Part B as the case may be. So we wanted to give you an example here. When we're talking about revenue codes on the hospital UB04 claim form, and we're talking about those ratio of cost to charges that are developed for various cost centers, CT, MRI, ultrasound, lab, blood, any of those categories, you can see here, this is an actual snapshot from the CMS revenue code crosswalk, and you can see how they are mapping those revenue codes from the claim form to the various cost centers on the cost report so that when you're actually getting over to your worksheet D-3, D Part 5, those areas of the Medicare cost report that calculate Medicare's share, they are actually just looking at it 1 plus 1 plus 1 plus 1 plus 1, as opposed to collapsing or consolidating certain information. So when you're working with your reimbursement specialists and they're really hammering home, can this cost center stand on its own, this is why. And we wanted to give you some more context behind those calculations and determinations. And when we're talking about those various areas, these are the national cost to charge ratios by consolidated cost center areas from inpatient, but they're also relevant on the outpatient side of the equation, because when we're talking about imaging modalities specifically, the year where CMS required that CT and MRI be split from radiology, you can see here for CT and MRI, CT's ratio of cost to charges has been going down over the years from 0.05 to now less than 0.04. And the reason being is that CMS was deliberate in breaking apart those cost centers because CT has very high economies of scale. You buy a CT scanner, it depreciates fairly quickly, but you're still charging $3,500 or whatever the case may be for a head CT with contrast. So they didn't want CT services to be reimbursed at a higher rate if the actual cost and charge profile was much less. The year that they required providers to do this, the payment rates for CT and MRI-related outpatient services went down anywhere from 30 to 50%. And so CMS uses these numbers to make those determinations. So it is vitally important that the cost of taking care of your patients and those Medicare patients that are settled through the cost report are as accurate as possible, because it is truly the provider's one chance to make sure that they are telling the optimized story for the amount of resources that are actually being used. So you can see this is actually a snapshot from a FAQ from CMS. And this is how the actual APC payment comes together. And I wanted to show the audience today this equation because each step along the way, when we're talking about APC payment rates, cost report data is vitally important to making sure that these payment rates are accurate with the cost that providers are actually incurring. So you can see that the conversion factor, the market basket adjustment that updates that conversion factor, comes from cost report data in the terms of salaries, supplies, malpractice insurance, blood costs. All of those various factors help to update the conversion factor year over year. And CMS uses what's known as a Laspers type pricing index, where they take a basket of goods and services and measure the change in pricing over a long period of time. So we want to make sure that if the market basket is essentially a consumer price index, that it is accurately showing just how much those costs go up year over year. And then in order to arrive at the relative weighting, the labor versus non-labor portions, those are also being taken from cost report data. So cost reports aren't just an annual settlement mechanism. It is actually a vehicle that CMS uses with their actuaries to make these determinations year over year. And with that, Emily, I'll let you do our first polling question.
All right. Our first polling question: do you or your team regularly compare your facility's data to posted values in CMS's rulemaking? And your options are yes, no, or I'm not sure. And I'll give everyone a few moments to respond. To participate in our polls today, please click the button next to the answer you choose and hit submit. Give everyone a few more moments here.
You know, while you're tallying the results, I'm curious, Paul, when we look at some of the payment cuts that we're going to be discussing in a few minutes relating to the non-accepted sites, and you know that CMS came up with its own relativity adjustment factor, Do you find that they're using the same methodology to get there? Did it work?
It's a great question, Larry. I think it's a function of that, but when we get to the Section 603, I think there's a secondary discussion when we're talking about modifiers. And we talk about the PN versus PO or various place of service. I would say that CMS's determination on certain cuts is not only a function of cost reporting data, but also the modifiers and other information that they're taking from claims specifically.
And it just happened to come to 50%.
Isn't that, it's a nice round number.
Funny how the math worked out that way, isn't it?
All right, let's go ahead and take a look at the results. Back to you.
Thank you, Emily. Not inconsistent with conversations that Larry and I have with individuals. We would certainly ask that as these rules come out, even if you're not reading the Federal Register specifically, making sure that you have, whether your payer contracting department is involved, compliance, legal, finance, reimbursement, making sure that organizations are working as one around some of these changes, because as Larry and I will talk about a little bit later, if you're not managing your Medicare Part A data, there can be an unintended downstream consequence because a lot of payers, including Medicare Part C plans and others, lately are defaulting to these rates. So you want to make sure that if this is the baseline number for not only Medicare, that it's as accurate as possible. So with that, as we transition from payments into 340B, I do want to highlight as a reminder for folks that CMS is still paying one common reimbursement rate for clinic services in 2018 and 19, and you can see the update between the 2 years here. As a baseline, and this is very high level, this is typically the payment rate with what you would see for a 99213 E&M type service. In 2019, they are still paying a payment differential between Type A and Type B EDs. As a reminder, the difference between the Type A and the Type B is similar to the difference between an emergency room that is open 24 hours a day, that does not have typically unscheduled type urgent care visits, where Type B, more similar to a blended methodology of emergency room services with immediate and urgent care, and you can see that reflected in these payment rates here. CMS has made certain shots across the bow over the past few years that they will correlate Type A and Type B ED services similar to the way they do for clinics, but at least the payment differential is intact for now. The last point I want to make regarding OPPS is that each year when CMS implements their various payment and other changes to OPPS, they take those current year payment factors and they go in and they actually recalculate your prior year outpatient claims using the current year methodology so you can see what the differential is facility by facility. What I did for the sake of brevity is actually summarize these by state, and you can see these are the top 10 and bottom 10 changes overall for OPPS payments. One of the items I wanted to highlight with this is not all changes in these OPPS payment rates are specific to either the actual APC payment rates themselves, but they also include things like changes to wage index, which happen on the inpatient side and carried over to outpatient. So there was a change with wage index calculation methodologies this year that is benefiting Massachusetts, and so we see a portion of that picked up in these OPPS payment rate changes. So I wanted to highlight that it's not always just cuts or other changes. There's a lot of moving pieces here, so it's important to evaluate these changes for your facility, your market, your state, on both the inpatient and outpatient side at these high levels to see where the changes take effect. With that, we will move over to the changes in 340B. One thing we wanted to highlight here, 340B is growing. I know facilities have started to take a closer look at this. If they are involved in 340B drug pricing, we see significant growth here, this last bullet point. The number of hospitals participating in the 340B program growing from just about 600 in 2005 to almost 2,100, 2,200 facilities in 2014. One of the big issues with 340B drug pricing that we have seen is that in order to qualify to participate in the 340B drug program, you have to have a disproportionate share factor on your cost report at a certain level depending on your facility type. If you're a DRG facility, it's a certain percentage. If you're sole community, it's a certain percentage. If you're a critical access hospital, you don't have DISH and you automatically qualify. What we are noticing is as Medicaid programs continue to evolve and enrollments change and the demographic changes of insured and uninsured patients in various states, that when we're talking about these disproportionate share percentages, there are facilities who have relied on 340B significantly for oncology drugs or drugs in various service lines, but they are finding that their percentage of disproportionate share, whether it's their SSI or their Medicaid ratio, is changing, and they are having to monitor that very closely so that they don't end up getting kicked out of the program by HRSA because something went wrong, either through a system conversion or data capture or Medicaid eligibility versus Medicaid paid claims. So that's one thing we're seeing with 340B in terms of the program, is encouraging facilities to really keep a close eye on that disproportionate share, because if you've cleared that 11.75% threshold as a DRG hospital, you want to make sure that you're staying on the right side of that equation if this program is benefiting your facility to that extent. Now, in 2018, CMS modified their methodology from the average sales price plus 6% to the average sales price less 22.5%. Those cuts carried forward into 2019, but we had a development earlier this month where finally the DC District Court ruled that they finally had subject matter jurisdiction over the case that was filed to put an injunction on these cuts. The interesting thing about this particular ruling is because of all of the various back and forth between the provider community, the American Hospital Association, and CMS, the judge in this case granted a request for permanent injunction, but did not rule on relief. He or she did not say, we're going to go back, these cuts are out, going back or going forward to a certain period of time. They just pressed the pause button. And Larry, because you've had more experience with these types of rulings in the past, I'd love to get your input in on this as well.
Well, as you can imagine, we were very interested in the court's decision here, not just because of the impact for our 340B hospital clients, but because of its potentially broader application. For those of you who like to follow this sort of thing, the reason that they claimed to not have subject matter jurisdiction is because no claims had been filed for reimbursement. And once they were, then once the claims had eventually been presented, then the court was able to take jurisdiction. And the question in the case really was, is CMS just tweaking its rates, which it's allowed to do through an adjustment process, or did they make something more fundamental, which was ultra vires or beyond their authority to do by law? And that's exactly what the facilities and the hospital association argued, and the court agreed that these were basic fundamental changes to OPPS reimbursement methodology, and they constituted a end run around Congress's clear mandate here. And what the court did was, as you mentioned, Paul, is they granted a permanent injunction, but they didn't know how to do relief here, and they've asked for more briefing from the parties on that. I think they have 30 days as of the 27th December 27th when the decision was formally entered. So we should watch those briefings closely. But I'll tell you what the court's worried about, among other things. They're worried about stepping into a quagmire about how you fix this, because unlike some of the other changes we'll talk about, these were budget-neutral payment cuts, which means that other rates potentially went up, right, Paul? And if they went and just reversed these decisions, there could be a ripple effect across other hospitals. And so the court's worried about the fact that there was ultimately a big rate reduction with wide applicability, and that, in their view, inexorably led to the conclusion that the Secretary had fundamentally altered the statutory scheme that was established by Congress, and therefore not an adjustment. In a little while, we're going to talk more about some of the changes that flow out of the Section 603 issues that you alluded to earlier, Paul. And I want everyone to be thinking about how that principle might apply to some of those other cuts. So with that, we got another polling question, don't we, Emily?
Yep. Time for our second polling question. Does Medicare reduce APC reimbursement if a facility fails to submit quality data? And your options are yes, no, or I'm not sure. And as a reminder, if you would like to receive CPE credit for today's webcast, you will need to respond to at least 3 of the 4 polling questions. We are on our second question. I'll give everyone a few more seconds to make a selection. And let's go ahead and take a look at the results. Back to you.
Very good. Thank you, Emily. The answer is yes, and it's very important to make sure that you're getting all of that data properly reflected and reported back to CMS as time goes on, certainly as there's more discussion about truly moving to that value-based versus volume-based system. So thanks to those who responded. And Larry, with that, I will pass it over to you.
Thanks, Paul. The topic that we want to move on to is relating to Section 603 of the Bipartisan Budget Act of 2015. And isn't it fascinating, Paul, that how much of a moving target this has been since just the fall of 2015? Just 3 years, we've seen multiple changes and reinterpretations, both statutory and regulatory, so that at this point, I think it wouldn't be an exaggeration to say that this is really the key Medicare planning issue for hospitals today, and it's therefore important to get right, not just for planning, but for future compliance issues as well. Every time Medicare or Congress makes a fundamental change to reimbursement like this, there's opportunities for hospitals to get it wrong, and that becomes a risk area, as opposed to, in addition, the planning issues of making sure that you get proper reimbursement for the services you're offering to your community. So let's talk about what Section 603 does. This will be a bit of a refresher, but there are a few takeaways that I want to make sure that everybody remembers. And one of them is that these site neutrality rules apply to off-campus services only. So for many of the services we're going to be discussing, for your on-campus facilities, you're still able to get fair reimbursement, historically fair reimbursement for your services for the Medicare program. And then determining what on and off-campus is has become a heck of a lot more important than it used to be just a few years ago. Just 3 years ago, we barely cared about on-campus and off-campus status for hospitals. Maybe it made a little bit of difference for some of your commercial payers. It was a little easier to claim provider-based status for the on-campus facilities than the off-campus, but not in any meaningful way. There were some other benefits to being on-campus, such as if you wanted to run a joint venture or if you had certain management contracts. But by and large, the reimbursement was the same, and so most providers didn't have a strong feeling about it one way or the other. Well, now it means a big deal. And so a lot of hospitals are much more carefully scrutinizing what is on or off campus, and in fact are making planning decisions in order to be within 250 yards of the main buildings of the hospital, or within 250 yards of a remote location, which we'll talk about in just a moment. We also are seeing organizations that are reaching out to their regional offices to get these individualized determinations of on and off campus made, which we historically hadn't seen. Unfortunately, many of the regional offices have been a little reluctant to make those calls because they know that there's a material reimbursement impact at this point. So that's one area where we are seeing hospitals that are taking some actions on that. This is particularly important when you have multiple hospitals that combine, and therefore one of those sites will have to be declared as the main campus. Thus, 250 yards spreads out from there, but also the 35-mile rule sets out from there as well. And you may recall that under the 35-mile rule or the location test, unless you can meet some very picky zip code rules or you have a specialized kind of facility, the general rule is that you have to be within 35 miles of the main buildings to even be provider-based to that hospital. So when you have the merged facilities, it's also important for these same reasons. It's though worth noting that many times the other campus in those multi-site facilities could be viewed as a remote location of the main campus, and thus you can still get credit for some of those services as accepted and therefore valuable. Keeping an eye on or keeping your nose clean in terms of your provider-based status is more important than ever, I would argue, because of the site neutrality rules. Although we have observed OIG and even Department of Justice interest in hospitals that have potentially failed provider-based status requirements. And that's a worthy audit work plan for those of you who are in your audit department or compliance department. One thing to think about is that the attestation process remains voluntary for hospitals, though you do want to make sure that your provider-based departments are listed on your provider enrollment 855 forms. And I'll tell you that the Medicare administrative contractors, the MACs, and the regional offices are scrutinizing these more than ever before, simply because of these rule changes and policies. I will note that more commercial payers are also not permitting additional sites to join hospital complexes for reimbursement under hospital commercial payer contracts and rates. So one useful tip here is that if you are in the Medicare reimbursement department of your organization and you're working on one of these projects, please include your payer contracting folks as well in the discussions so that they can coordinate for contract renewals and revisions. Let's talk a little about dedicated emergency departments. Dedicated emergency departments are one type of hospital department that is statutorily protected from the Medicare site neutrality rules. And in fact, as CMS has said about multiple rounds of regulatory changes, they have continued to protect the DEDs, as was congressional intent here. The interesting thing about the definition of a DED is that it, through in Congress's wisdom, and CMS has continued to protect it, they've defined the DED through the EMTALA, or the Emergency Medical Treatment and Labor Act definition, which, as you may recall, was designed to bring more off-campus departments, more hospital departments within the definition of a DED in order to give patients the protections of EMTALA, the patient anti-dumping laws. So this is, in my view, a relatively broad and expansive definition of what a DED is. You either are state licensed as an emergency room or emergency department. If you do that, you could be held out to the public as a place that provides care for emergency medical conditions on an urgent basis without an appointment. Or mathematically, at least one-third of your outpatient visits are for those emergency conditions without an appointment. And if any one of those triggers is met, you're a DED, or your department is at least, and that's a good thing because then you're protected against site neutrality. So we're urging our clients to carefully scrutinize their facilities to see if they meet one of these standards, because if you do, then all the services there are exempt from site neutrality, not just emergency services. And if the Section 603 changes weren't enough to cause hospitals to recalculate this status, the 2019 payment changes that we're going to discuss in a few minutes, Paul, double down on the importance of being a DED, in my view, because the new changes for clinic visits don't apply to DEDs at all. So let's move on and talk about what facilities are accepted and not accepted under Section 603. And this is a bit of a refresher, but again, it's worth reminding everyone that this only applies to the off-campus provider-based departments. And to be grandfathered, that department has to have been billing under OPPS prior to November 2, 2015, the date of enactment of the Bipartisan Budget Act of 2015. And if you are, if you're a facility that's lucky enough to have that grandfathering, that is thus accepted from it, then you're free from site neutrality, with the exception of the new clinic visits under the code GO463, which we're going to speak about a little bit in a moment. The trick here is to make sure that not only do you know which of your departments are in fact grandfathered, and there remains a lot of ambiguity in the industry about that, and we can talk about that during Q&A if anyone has any. It's important to not jeopardize your historically accepted or grandfathered status, and you can screw it up in a couple of ways. One is you could relocate the facility from the physical address on the provider's enrollment form. The second is you could potentially expand it into areas that the historic footprint didn't cover. And those are two areas where we think that as organizations grow and change, that'll be a meaningful thing to worry about, or at least to plan around. Another area here to be cognizant of, and that relates to one of the points we had on an earlier slide, relates to hospitals that merge and change their configuration. Over time, this will certainly happen as hospitals build or change their physical plant and footprint. They build new main campuses. They're combining multiple hospitals and multiple entities. In our view, from Paul and my perspective, this is a time for a very careful financial analysis to make sure that you at least know what the impact will be for Medicare reimbursement on making those changes. And sometimes the numbers will be significant enough that it will cause a delay or at least a rethinking of some of these rules. This is also an issue in the context of merger and acquisition or change of ownerships of hospitals, because the CMS rules are clear that if a provider, a hospital, is sold in its entirety, that its provider-based status exemptions will transfer to the new ownership, so long as they don't have a material change to the provider-based status. And the new owners must accept the hospital's provider agreement. We crossed the bridge a long time ago that hospitals that want to acquire other hospitals generally have to pick up the provider agreement, or else they will experience a significant delay in getting a new provider agreement issued. And so the vast majority of organizations choose to accept the provider agreement. In this case, here's another reason to do so, because you'll probably lose your accepted status for those off-campus departments if you don't. Other things in contrast, what you can't do is you can't sell just your outpatient department, just one to another hospital. You can't transfer it from one hospital to another. If you do, it will lose its accepted status under Section 603. So even if that's more rational within a health system, it can't be done without making a significant reduction in Medicare reimbursement. I would also offer a word of caution if you are entering into a transaction where even if you're accepting provider agreements, you have two hospitals merging in and becoming one single standalone hospital. There are a few consequences to that, one of which will be, as we mentioned earlier, that there will be a new main campus, but it could strand formerly grandfathered sites. And this is an area that I think you don't want to stumble into this one. You want to do this one mindfully and with the attention of the regional office, if at all possible. The new modifiers are becoming more important than ever, I think. Obviously, you have to get your modifiers right. There are new place of services for on and off campus hospitals. We've listed them here. I'd expect that everybody in your billing department is familiar with them. One of the reasons they become so important is that these will also not only indicate which units are going to be receiving the payment cuts for being a non-accepted site, but also in the context of the payment cuts for the clinic visits, these modifiers are the ones that are going to trigger the payment reduction. We have a new topic here, unless we have any questions that seem like they would be relevant to these particular topics. And so far, I don't see any. Paul, did you have anything you wanted to add before we move on to co-location?
Not at this point.
Okay. Well, we can come back to it if we want to, but let me mention a few other issues that I think have been relevant to both the clients served by both of our firms. And one of them is the so-called co-location principle. For those of you who aren't familiar with it, I'd encourage you to dust off some of the e-alerts that we at Foley and Moss Adams have pulled together over the last several years, because it's a relatively new concept. And the concept arose out of Region 5 in the central part of the U.S. back in 2011, when the regional office issued a letter in which it was denying the provider-based status of a particular outpatient hospital department. But it did so and expanded upon a concept known as co-location, which to them meant that if a hospital department wasn't under the hospital's control for 24/7, if it was shared space with a freestanding entity like a physician organization, then not only could it not meet the provider-based status, but the hospital might jeopardize its conditions of participation in its entire provider agreement for doing so. A very far-reaching position, which was not appealed, unfortunately, in that instance. And so the letter, though not precedential, is sitting out there like a skunk at the garden party, and we have been having to live with it ever since. Interestingly, that letter is not the last word from CMS on it. A few years ago, the central office participated in preparation of several training slides and a training presentation that went on for the state survey agencies and also for the accrediting bodies on the co-location principle. So what Paul and I have done on the next couple of slides is offered you the key takeaways on these issues so that you can track them yourself. I won't read all the slides to you, but I would encourage you to look at them at your convenience. The things that the CMS has been interested in have related to things like physician offices that are nestled into a hospital outpatient department, either full-time or part-time. And if you think about many organizations, they'll have a freestanding physician clinic, oftentimes the physicians that are affiliated with the hospital through an affiliated group practice, or independent physicians in places that are remote or rural, where specialist physicians have to come from miles away in order to treat patients. They need places to work. The things that the CMS is worried about is, in fact, that carving out of hospital space to be served by the physicians as non-hospital locations. And the things that they ask the surveyors to look at, and thus the hospitals are studying, is whether you have exclusive entrances, waiting rooms, registration areas. Are there permanent walls that separate the physician and the hospital services? Do they have distinct postal service designations? I almost want to pause here and let that sink in, because I can think of a majority of hospitals that have situations like this because that was what was necessary to care for the patients in their community. The things that troubled CMS the most were shared entryways, shared interior hallways, shared bathrooms, shared treatment and waiting rooms and registration areas. Again, these have been very common arrangements, often structured to meet fraud and abuse or Stark law protections. In fact, just around the same time as these issues were bubbling up, CMS issued a special Stark rule to allow timeshares so that when hospitals and other providers were allowing physicians to use space for a part-time basis, they could find a way to get paid for them and not violate the Stark law, while at the same time survey and certification is saying you really shouldn't do that. Other things that we pulled from the training materials include their fear of commingled staff, service agreements that make it look like the hospital and the physician organization are a bit blurred, including around EHR and paper record. I'll note that CMS has not backed down from this seeming policy, nor has it clarified or interpreted these rules in a notice and comment rulemaking, as they should for something as important as this. Providers have been attempting to comply with these tea leaves that we were trying to read together, particularly when it comes to new construction. When tens of millions of dollars are being spent on an outpatient department facility, it would be a real shame if later on your surveyor would say that's illegal. And I can tell you that I'm aware of projects that have been deep sixed because of such concerns. So as a result of this, the provider community has asked CMS for further guidance on that, and CMS has promised that guidance for at least the past year. I can tell you that the guidance is complete. It has been drafted by the staff, and it is in high-level review at CMS and maybe elsewhere within the government. We've been hoping that the guidance would come out as recently as last November. The spokesmen for CMS have promised that the guidance will come out early this year. I'm even expecting that if it came out this month or next month, that wouldn't surprise me. And so a lot of us are waiting for this. I will give you some indications that we've picked up from comments that folks at CMS have offered. And while we cannot make promises about any of these, I can tell you that we are expecting some more flexibility for hospitals, and that'll be welcome relief for many folks who've been worried about some of their existing facilities for sure. I think that things like signage, which is an existing part of the provider-based rules, will become all the more important, so that if there are shared waiting rooms that are permitted in any fashion or shared corridors, good clear signage will make the difference. I think we will still see them being very hostile to patients that are freestanding patients who are going to one of these non-hospital locations, having to cross over hospital space, particularly inpatient space, to get there. I believe that there will be more thoughtfulness towards the staffing of these freestanding and hospital facilities, and I don't think CMS is going to really want to see nursing and other services working between both of them on the same day of care, because they're worried about that confusion. They're worried about what happens if a code rings and they don't know who to get called. They don't know whether that person's on their freestanding duty or are they on their hospital duty. And those, I have sympathy for those concerns. I think that those are reasonable things to worry about. But we are seeing a sense that they are a little more open to revision than perhaps they have been in the past. There have also been some staffing changes in that division, which is very important and probably will help relieve some of the strictness that we've seen. I also think that they've heard the concerns from the rural hospital community that they simply can't have physicians coming in without allowing some of this co-location that's necessary for patient care. So we are still waiting to see what the outcome will be of CMS's decision-making process. I give a lecture at the Medicare and Medicaid Law Institute for the American Health Lawyers Association every year. And this year we will be talking about it, and the drafters of this policy will be in the room with us. So here's a little pitch. On March 20th, if you have nothing better to do, come to Baltimore and hear what we have to say about that and other topics. Paul, any comments on this before we ask Emily to read us our third polling question? Hearing none, Emily, would you mind giving us our third polling question?
All right. Our third question: has your facility recently reviewed the location and nature of off-campus provider-based services and the potential impact of continued action by CMS? And your options are yes, no, or I'm not sure. And at this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter the 5-digit code into the survey question that will appear on the screen at the end of the program. And the code is as follows: P as in pony, the number 8, the number 5, R as in red, and Z as in zebra. If you are seeking CLE credit for this session, please complete the survey question at the end of the program by entering the code that was just announced. For those seeking Kansas, New York, and New Jersey credit, in addition to the survey question, you will need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in the slide deck and handouts widget. And as a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webcast. And let's go ahead and take a look at our results. Back to you.
Okay.
Wow. Okay.
So I say good. Those numbers are not surprising, and I think that you'll see the yes spike even more next year for reasons like the 2019 bombshell, which is a change to site neutrality beyond what Congress intended for for outpatient hospital departments off campus. And let's walk through that in our last 5 minutes together, Paul, me and you. So this change, effective as of 1/1/19, was to reduce payments for the clinic visits, the most common visits, the physician office visit, the E&M visit in the hospital outpatient departments by 50% to effectively give it the same discount as the non-grandfathered departments would have. But the killer here is that this payment cut applies both to the non-grandfathered and the grandfathered facilities. So even the facilities that were billing under OPPS prior to November 2, 2015 are getting this haircut, and it's going to apply to an awful lot of services. I'm interested in, Paul, your reaction to how much of a financial impact this will be to our hospitals, because in my non-financial expert perspective, it's going to be a big one.
Absolutely, and I think what we're seeing here, certainly if providers have a significant concentration of off-campus internal and family medicine services, and I know there are providers out there that do, I've heard numbers thrown around anywhere between $1, $2, and $8 million for some of the larger hospitals and health systems. So this is a big change. We're also seeing folks take proactive steps to truly evaluate the location of on-campus and off-campus services, and if there can be a reconfiguration of location while still maintaining provider-based status, we have seen facilities take measures to move those services that are falling under that G0463 code back on campus to mitigate some of this offset.
But what a rotten reaction, Paul, because the very reason that the hospitals pushed these outpatient departments into the community is because the patients needed the flexibility of getting to those locations as opposed to oftentimes in the inner city or in a more inconvenient location to the main campus. So I've also seen what you're describing. The thing that frosts most of us is that we think that I believe that CMS well exceeded its authority on this one. Congress was very clear. There was a negotiation about where to draw that line. They could have drawn the line based on the types of services and said even the existing facilities wouldn't be covered by it, but that's not what Congress did. Congress drew a line in the sand and said if your facility was billing under OPPS by November 2, 2015, you're going to be safe from these payment cuts. And CMS has gone well beyond that authority. So I think that the 340B case is directly relevant to these issues as well, because CMS has gone directly beyond what Congress intended, in my view, in this round of payment cuts. I do not think, though, that we have seen the end of this. I don't believe that if they're successful in court beyond on this one issue, I don't think we've seen the end of site neutrality. We know that the administration and other payers love site neutrality. They think it seems fair. Here, the HHS secretary has referred to it as a perverse situation that they've talked about for years. If any of you have read the Trump administration's manifesto on health, which came out just a few weeks ago, site neutrality remains a key function of that. So I'm not seeing much of a change in this going forward. I don't know about you, Paul. And we do have one last polling question we need to get to. So maybe we'll do our last polling question, and which is actually a quiz for those to see who's paying attention before we ask any final questions.
All right.
Emily?
Our final polling question. What is the distance requirement to be considered an on-campus department? And your options are 50 yards, 1,000 feet, 250 yards, or 100 meters. And once you have completed all CPE requirements today, you will be able to download a PDF of your CPE certificate from the certification widget to the right of the slide view. And then if you are looking for CLE credit, the code is P as in pony, 8, 5, R as in red, and Z as in zebra. And let's go ahead and take a look at the results. Back to you.
Paul, we've got good students today. They were paying attention.
Absolutely. That's great. Thanks to everyone who responded. Quickly, at the advisory board level, we borrowed a handful of slides and gave them appropriate credit here. But they had a couple of good infographics that we wanted to share with the audience to close out today. When we're talking about this particular G code on the claim that Larry and I have mentioned, we wanted to show you this is the breakdown of how that G code represents these various clinical disciplines. So you can see when we're talking about internal and family medicine, certainly a predominance there. Larry, as you mentioned, when we're talking about off-campus internal family medicine services in the community, we want to bring the clinical care to the patients where they can get and access those services easily by having them out in the community and folks understand how to appropriately use primary care services close to their home. It allows them to not have to come on campus to the hospital, which is what we've been attempting to avoid with folks using the ED as their primary care department. So as you mentioned, sometimes CMS's thought process around cost isn't always aligned with proper clinical pathways to meet the needs of beneficiaries.
We want to be respectful of everybody's time, so we probably ought to wrap it up, Paul. There are a number of items that we didn't cover today that relate to these issues, including those providers that had mid-billed requests in place, and there are some winners and some losers all of a sudden. You know if you are, which one you are. There's also a number of state law initiatives, both through state attorneys general and through state legislatures, pushing for site neutrality. Some of the takeaways from this are that good signage and documentation and forms are going to make a big deal. I wish we had more time to discuss these issues, Paul. Did you have any final comments or last licks here?
Keep an eye on rulemaking. As Larry mentioned, it's coming heavier and heavier each year, and so make sure that you're staying on top of these, whether it's through webcasts, blog posts through Foley and Lardner, any of the newsletters that you subscribe to. Make sure that you're correlating whatever's happening to your specific facility situation.
And our blog is www.healthcarelawtoday.com. It's free for friends and clients of the firm, and we welcome you all to subscribe if you're interested. That's all I've got. Thank you all for your time, and thank you, Moss Adams, for pulling together such an interesting group of people.
Thank you, Larry. Have a great day, everyone.
Bye.
All right. Thank you, Paul and Larry, for a great presentation today. As a reminder, if you attended today's presentation in a group and would like to receive CPE credit, you must complete the group attendance sheet found in the slide deck and handouts icon to the right of the slide view. If you participated as an individual and met all certification requirements, your certificate is available to download now in the CPE progress window to the right of the slide view. I'll keep the webcast console open for a few minutes to give you time to download your CPE certificate. A copy of your CPE certificate will be emailed within 2 weeks should you have any difficulty downloading it now. And if you qualified for CLE credit today, your CLE certificate will be emailed within 8 weeks. If you have any questions for our presenters, feel free to enter them in the Q&A box, or you can reach out to them directly. And here is a link to an online survey where you can provide feedback for today's presentation. Please take a moment to complete this survey, as your feedback is very important to us. Thank you for joining us today, and we hope you'll join us again next time.